Will everyone just note their appearances? With all the attorneys, we have myself, Justice Swan, Justice Cabret, Attorney Francis. Can you identify yourself, and then we just go as you appear on the screen?
Yes, good morning, Justices Simone Francis, Ogletree Deacons, Nash, Smoke, and Stewart, on behalf of Appellant R.J. Reynolds Tobacco Company in case number 2019-49 and 2019-50.
Okay. Attorney Lawrence?
Good morning, Your Honors. Attorney Rhea Lawrence with Lee J. Road and Associates on behalf of the appellee, Jaida Gums, in appeal number 2020-0025.
Attorney Gregory?
Good morning, Assistant Attorney General Aisha Gregory on behalf of the appellant, the Government of the Virgin Islands, in the matter appeal number 2020-0025. Government v. Jaida Gums.
Attorney Herlick, I understand you will not be arguing, but
Correct, Your Honor. Attorney Julie Everett on behalf of Law Office of Julie Everett, as co-counsel with Attorney Lawrence in the case of Government versus Jaida Gums, the appellee 2020-0025.
okay. Attorney Rhea?
Good morning, Your Honors. Gordon Ray. I represent the appellees in the matter involving R.J. Reynolds.
Thank you. Attorney Garvin?
Yes, this is Michael Carvin on behalf of Reynolds in the same matter.
Very well. We will formally call up the first case, which is R.J. Reynolds Tobacco Company, successor of a merger of Lorillard Tobacco Company versus Javon Gerald, case number 0049 of 2019. And Christian, the second case, Christian Brown as the executor of the estate of Patrice Brown, and that so we will start off. I understand that Attorney Carvin will argue for 16 minutes. Attorney Francis will argue for 8 minutes, and the reserve about rebuttal time will be by Attorney Carvin for 6 minutes. So for the appellant, you may proceed.
May it please the court. Thank you, Michael Carvin for Reynolds. The time division is as Your Honor just said. And if it's amenable to the court, Attorney Francis will be handling the excessive compensatory damages issue, as well as the comparative fault issue, where I will be handling the improper argument question, as well as the excessive punitive damages and the question of prejudgment interest. In terms of improper argument, to begin, I think there's a consensus in all courts that the most obvious form of improper argument is criticizing the defendant for mounting a defense. You are penalizing him or her for exercising their constitutional rights, and you're poisoning the jury against their ability to be open-minded about the defendant's presentation. There's a series of Florida cases also involving tobacco plaintiffs that have ruled these arguments improper, and the Wittenberg case written by then Judge Gorsuch in the 10th Circuit. And the plaintiffs here in 3 different ways criticized us for exercising our right to defend ourselves. Most obviously, they repeatedly said that we had failed to accept responsibility in the court. In other words, we had to sacrifice our defense. We had to admit liability, and our failure to do so should be held against us. The second consistent theme was what they called ABC. Their plaintiff had said that Lorillard had engaged in fraud called ABC, which is anything but cigarettes. They tried to link us to that fraud by saying that our efforts to debate things like whether or not cigarettes had caused cancer was again a perpetuation of the fraud that had been perpetrated because we were saying anything but cigarettes. A variation on that theme was ABC always blamed consumers. They said that that's what Lorillard had done during the fraud era, and that's what we were doing at trial by acting as con men to attack victims. The only defense on the merits that I believe the plaintiffs are arguing for these improper arguments is that they were not attacking us for our behavior at trial. They were attacking Lorillard for its behavior during the fraudulent period. But they provide no cite for that because that's completely contrary to what happened. If you look at, for example, page 6 of our reply brief, it lists a number of quotations where they are criticizing what we were doing at trial at this hearing. And of course, it doesn't make a lot of sense. When else would we have debated causation, what caused the cancer, except at trial? So necessarily their criticism was related to trial. When else would we have accepted responsibility in front of the jury except at trial? So obviously these were criticisms relating to our defense, not criticisms of Lorillard in the past. They make much also of the fact that we failed to preserve our objections, but that's not true. As to each category I've already articulated, and I can walk through in detail if the court desires, we entered timely objections to all three forms of those improper arguments. Now, it is true that we did not object each time that these arguments were repeated, but that's not important for two reasons. The first reason is, as Thomas and other courts have made clear, if the court has overruled the objection, you need not keep repeating the objection. For the obvious reason that if the court has overruled your objection, then the court has given its imprimatur to that kind of argument. You would simply be exacerbating that harm if you continued to object, drew more attention to it, and had the jury understand that what you're arguing is improper is actually quite proper. The second reason is, since we preserved the objections to the improper arguments, the only question as to the other things is whether or not those other statements had the cumulative effect of prejudicing the jury. And a number of cases have held that if you're looking at cumulative effect, you can look at both the unobjected to and the objected to statements, because obviously that's what you're trying to figure out. What is the cumulative effect? In terms of prejudice directly, the Third Circuit has said the question is whether it's reasonably probable that you've influenced, the improper arguments influenced the jury. And I think that's essentially the same standard that's used throughout. We know there was prejudice here because, again, the Florida courts and
are you saying that the plaintiffs were wrong to raise the ABC argument?
Yes, they were perfectly free, just to be clear, Your Honor, to criticize us for denying causation and for saying that the victim knew about the health risks of smoking. That was all fair game. But why did they use the formulation ABC? It was no coincidence. That was the formulation, as they kept reminding the jury that Dr. Proctor had used when he was criticizing Lorillard for engaging in fraud. So what they were trying...
Since that was an evidence before the jury from Dr. Proctor, why wasn't it proper to raise it in closing arguments?
Oh, they could certainly argue that Lorillard engaged in fraud and reference Dr. Proctor's testimony. What they couldn't do is link Lorillard's prior fraud to our defense at trial. In other words, what they were saying was that our very legitimate defenses at trial, such as saying, for example, disputing whether or not cigarettes had caused cancer.
Well, you were saying that the cigarettes, that she didn't have the small cell cancer, which
right,
I guess is caused by cigarettes, and that it was caused by something else. So why
right,
wasn't the argument that it is anything but cigarettes not relevant in that situation?
Again, they were perfectly free to argue that we should not have denied that cigarettes caused the lung cancer. What I am objecting to is they were trying to suggest that our legitimate defense was perpetuating the fraud that Lorillard had perpetrated on the victims. In other words, they're saying that because we're disputing causation, that's like what the tobacco companies had done in the 60s and 70s about denying the health effects of cigarettes. It's the linkage between the prior fraud and our legitimate defenses at trial, which quite explicitly is saying that what they're doing at trial is fraudulent. Well, that is criticizing us for exercising our constitutional right to debate issues like whether or not it was really our product that caused the cancer. And that is what the Florida...
Attorney, I have a question because this anything but cigarette, I believe that you have read too much into what it meant. My understanding of that is that the tobacco company is saying that whatever cancer, whether it was the bladder cancer or the lung cancer or the throat cancer, that was caused by something else.
Right.
And it's anything but cigarette. And then they went into this long thing about particularly as to the gentleman Evans. A whole lot was made that he was, perhaps he get it job related, perhaps he get it from the two wells, he live in the area, perhaps he get it from something else. But I did not understand them to be criticizing your defense. I understand that anything but cigarette means that you were pointing to other things and saying that this could be caused by XYZ, including by the merit cigarette rather than by Newport. But anything but cigarette, I don't read all that you have read into it that they were criticizing your defense at all. They said that the tobacco company has a long history of blaming everything else, including saying or suggesting that it would be perhaps part of the fault was on the victim because the victim could have stopped smoking at any time, which is not necessarily so. So I don't read too much into this anything but cigarette defense at all.
Well, I won't pound the point if Your Honor is unpersuaded, but I do think the key point.
You have two other justices.
No,
speak for them.
No, fair enough. But at the risk of repeating myself, it was perfectly fair game for them to say that we are completely wrong in saying that non-cigarettes cause their cancer. But it's not a coincidence that they chose the letters ABC, because that's what as they expressly referenced, their expert had accused us.
Those letters are in evidence. The plaintiff's experts, one of the plaintiff's experts, used the phrase anything but cigarettes.
Yes.
Isn't their argument then based on evidence? I understand that you are arguing that they're linking the expert's testimony to the defense that Reynolds is putting forward or was putting forward. But frankly, I'm trying to understand your argument, just as Justice Swan is, I think.
Fair enough. And what I'm trying to convey, Your Honor, is it's the follows. It was in evidence. They said we engaged in fraud, ABC. Now we come up at trial, and we're arguing about whether or not these particular plaintiffs' cancer was caused by the cigarettes. And instead of saying that's medically illegitimate, they say this is just like the fraud that Lorillard had perpetrated on the public. So what they are linking a legitimate defense at trial to a fraudulent activity by the company in the past. And by linking in that way, what they are saying and what the Florida courts have consistently condemned is that our defense at trial, which any other defendant could have put on, can't be put on by us because it's perpetuating the prior fraud of the companies. And we think that penalizes us from exercising our rights to defend ourselves, to mount a perfectly legitimate causation defense. I can see that I'm running out of time, and with the court's permission, I'd like to switch to punitive damages unless Your Honors have additional questions on this point. So on punitive damages, obviously we have in the GERARD case a punitive damages award that's 30-1 from the compensatory, the very substantial compensatory damages award of $1 million. And the Supreme Court has provided very express guidance on the requirements of the Due Process Clause in this regard. They said that anything that's above 9 to 1 is per se impermissible in, quote, all but the most exceptional cases. That's from Exxon. In Campbell, they said normally the outer limits for any kind of ratio for punitives to compensatories is 4 to 1. And in the case of substantial compensatory damages award like those at issue here, the line is probably closer to 1 to 1. But we have something that's almost 8 times the 4 to 1 ratio, which is virtually unprecedented in terms of any punitive damages awards. In the Florida courts, for example, again,
should we consider the second $1 million in terms of the ratio?
No, Your Honor, you shouldn't for 2 reasons. First of all, they just argue this in a footnote that you should consider it as part of the ratio. But the courts have been clear, the only part of the ratio that matters is legally recoverable damages. And since the jury found that the second laryngeal cancer was time barred, that's not legally recoverable. If you said that they could be used, that could be used in the ratio, that's saying that time barred claims are entitled to the same ratio analysis as those which satisfy the statute of limitations. That is essentially eliminating the statute of limitations and all of its virtues in terms of what's going on. In other words, you're allowing them to accomplish through the back door what they couldn't accomplish through the front door, which is get compensated for time barred claims. So there's not a case in the country that allows you to recover for damages that are not legally recoverable. And in terms of the 30 to...
When the jury assessed those damages, it did not know that the result of their finding that it was time barred would be that those damages would be denied, right?
I think they probably figured that they were asked a reason if these were time barred, and the most natural inference is yes, they did. But regardless of what the jury's knowledge of that legal question was, the relevant point is that as a legal matter, they couldn't recover for these damages. So you can't reward them in terms of additional punitive damages for compensatory damages that were legally prohibited. Again, I don't think there's any dispute in the case law on this, and plaintiffs have not been able to cite a case to the contrary. The case is...
But it has not gone beyond where the conduct was so reprehensible that it may justify a higher award?
Well, 2 points on reprehensibility. The Supreme Court decision in Campbell couldn't have been clearer that reprehensibility is a factor, but it's one of 3 factors. And you can't use reprehensibility to eliminate the very specific guidance on improper ratios, excessive ratios. If you did, you would essentially eliminate that as a factor. And as a common sense matter, of course, Your Honor, every punitive damages defendant has engaged in conduct that could be characterized as reprehensible, right? It's willful and malicious, and it causes a lot of harm. So the notion that reprehensible behavior somehow takes you outside of the ratios doesn't make a lot of sense. What the Supreme Court was saying was, if it's really reprehensible, you can go to the outermost limits of the ratios we've been talking about, 4 to 1 or 9 to 1. But it cannot possibly justify exceeding the ratios, because then you've eliminated the ratios as any kind of meaningful guidance. We've had a laboratory experiment on precisely this issue in Florida, where every one of the defendants' punitive damages was a tobacco company with allegations very similar to what were found here. And in 7 awards, where they went over the 4 to 1 ratio, in 5 of those cases, the Florida courts remanded that back to 4 to 1. And in the 2 that exceeded 4 to 1, neither one exceeded 9 to 1. One was 6 to 1 and one was 7.5 to 1. So we can see that this reprehensibility of tobacco companies' argument can't possibly hold enough water to do away with the very separate analysis of whether or not the ratios apply. Again, the ratios are always involving people who have engaged in relatively bad behavior because they're being subjected to punitive damages in the first place. The only
how about the fact that the $1 million may be considered insubstantial, at least as compared to the Brown case?
Well,
not a factor?
Well, no, because Campbell speaks directly to that. Campbell, it was a $1 million award in the Supreme Court. The Supreme Court said this is a substantial compensatory damages award. They want to argue, yeah, but we behaved worse than the other people. We were more reprehensible. But that has it precisely backwards. The Campbell court cautioned courts, you should be very wary of pain and suffering damages that amount to, say, $1 million, because they have a, quote, element of punitive damages in them. In other words, they're being punished because of their bad behavior in the compensatory damages award. So Campbell was saying, if anything, don't take it at face value, be suspicious of it, that may be overcompensating. And that's what they're asking you to do here. They're asking you to count reprehensibility twice by pretending that $1 million.
Let me ask you, let's assume that it is beyond the ratio and is considered excessive. What does this court do to remedy that?
The simplest course would obviously be just reduce it to what the constitutional outer limits are. We would argue that's 1-to-1 because it's a substantial compensatory damages award. But at a minimum, it's 4-to-1.
Then you would agree that if we were to reduce it to a constitutionally acceptable manner, even if it is 9-to-1, that we could do that without you having the right to reject that and have a new trial.
Right. Well, obviously, neither we nor, yes, the courts have taken the position in these punitive damages awards that it's not remittitor. The courts can just unilaterally cut it without having the plaintiffs agree or anything else. And even this court's interpretation in Antilles, I believe, said that they can, courts can alter verdicts in cases of unconstitutional damages. And that would be this case. So yes, I think it's well within the court's power. The Lompe case in the 10th Circuit collects all the cases that have done that. And it's quite uniform for courts to simply reduce the excessive punitive damages ratio to one that is constitutionally acceptable without offering remittitor. And even if it were an issue under Antilles, Antilles created an exception for unconstitutional damages.
Okay.
I apologize, Your Honors. I don't know how much of my time I've used up.
You've gone into Tony Francis
Yeah.
this time a little bit, but I'm sure she'll make her argument accordingly.
I don't have a clock in front of me, so I apologize, but I will stop now.
Can you see the clock on the screen?
Unfortunately, I cannot. I apologize. Why don't we go ahead and I'll see if I can fix that in the meantime.
Okay, it should be on the screen, but Attorney Francis, you may make your arguments.
Okay, thank you. Thank you, Your Honor. I'll make my two arguments and then wrap up with Attorney Carvin's third argument that he didn't get to. A new trial is warranted in Brown because the $70 million non-economic damages award is not supported by the evidence, exceeds by several orders of magnitude every personal injury damages verdict in the history of this jurisdiction, and if allowed to stand, would violate Reynolds' due process rights. And at an absolute minimum, as I hope to have time to get to, the judgments in both Brown and Gerald must be reduced to take into account the jury's findings that the damages were caused in part by the plaintiff's negligence. When this court adopted the rules of civil procedure for the Virgin Islands, it exercised critical forethought by including Rule 59A, which, unlike its federal cousin, specifically and expressly provides that a court can order a new trial when a jury awards excessive or inadequate damages. Coming as that rule did on the heels of a decision that remittitor does not represent the soundest rule for the Virgin Islands, the reserved authority of this court to order a new trial stands as a recognition that although juries play an important function as triers of fact in our judicial system, if a jury returns a verdict that by virtue of its very enormous size or its extremely small size reflects that it is not a product of the properly admitted evidence in this case, this court is neither powerless to recognize and declare error nor impotent to order a remedy. The reserved authority that this court carved out to set aside a damages award which is not supported by the evidence while leaving to another jury to reach a different verdict is appropriately invoked in Brown for several reasons. First, the extraordinary damages award in the Brown case is excessive in light of the evidence in the case. Second, the extraordinary awards are excessive when compared to other personal injury cases in the territory. Those awards are excessive when compared to awards in cases in other jurisdictions, and they are excessive when compared even to the amounts that counsel for the plaintiffs urged the jury to award. When our Wrongful Death Act was amended in mid-2001 to provide a cause of action that did not exist for the first 44 years that this law was in effect, and allow an adult child to pursue a claim for lost parental companionship and mental pain and suffering, while that did occur, there was no evidence to demonstrate that Christian Brown had any physical or mental disability or other unusual circumstances that caused him to be uniquely and extremely dependent on his mother for companionship, instruction, and guidance even into adulthood. As appellees acknowledge at page 33 of their brief, the evidence demonstrated that at the time of his mother's diagnosis in 2008, Mr. Brown was an adult in his 40s who had earned a college degree, was residing in California where he had a job, a wife, and children. And he was not present for any of his mother's treatment in New York. And with the exception of brief visits to St. Thomas, he remained in California. And while the jury was properly charged with the responsibility and duty to determine a fair, reasonable, and adequate compensation for the natural grief caused by the loss of his mother, about which Mr. Brown testified, the award of compensatory damages exceeded by a multiplier of 20 the damages awarded in GERARD for the pain and suffering that Lucy in England was alleged to have endured due to the throat cancer that resulted in an incision in his neck, or due to the bladder cancer that caused him to become dependent on a urostomy bag. And although the appellees argue that $20 million to an adult for grief due to the loss of a parent at age 44 is not excessive, no challenge was made in the trial court or in this court that the $1 million to compensate for the pain and suffering experienced by someone diagnosed with cancer is inadequate. Similarly, the award to Patrice Brown or to Christian Brown in his capacity as the survivor of the estate of Patrice Brown is likewise excessive. It is 50
So
times.
how do we determine that that there's not sufficient evidence to support this particular these two verdicts?
Your Honor, I think certainly this court has to make a judgment looking at the evidence in this case compared to, as we suggested, verdicts in other cases. The Brown case is certainly tried in this jurisdiction at the same time involving a similar illness, and the verdicts to Patrice Brown is an order of magnitude of 50 times larger. There was just not a sufficient difference to get to that 50 multiple. I see my time is about to expire, Your Honor. And looking at verdicts in other jurisdictions, including the Munn case, which plaintiffs also point to, that was a very different case involving somebody injured as a teenager, expected to live an additional 66 years, who had $10 million in economic damages. So whether this court compares it to Brown, which we consider similar, other personal injury verdicts in this jurisdiction, or verdicts elsewhere, that award is excessive, and Rule 59 certainly allows this court to order a new trial whether the excessive damages are economic damages or non-economic damages. We submit that authority would be appropriately invoked in this case. Your Honors, I see my time is...
You think that we should do that at this stage, or should we remand it back to the trial court to make that determination in the first instance?
Your Honor, I think that what this court indicated in Antilles and also in Balboni is that while this court doesn't determine the proper amount of damages, it can determine as a matter of law that $20 million to an adult survivor who loses his mother in his 40s and the $50 million that's 50 times the Gerald Award are excessive as a matter of law and remand for a new trial where a new jury can make a determination. That's our reading. As we indicate, we also believe submit that the awards violate the due process clause and are unconstitutional, and Antilles also recognizes that as a basis for setting aside an award. But even before the court
Attorney, I see that your time is expiring.
Yes, I do. I didn't get to my other issue.
You referenced Rule 59, our Rule 59, but I thought you mentioned B. Did you said subsection B of Rule 59?
No, 59A, Your Honor, is where excessive and inadequate damages.
It is 59A. Okay, all right.
Okay.
And the second thing is, attorney, we got to be very careful, and this is one of my problems. This trial was 4 weeks. It ran for 4 weeks. Am I correct?
That is correct. Yes,
Yeah,
Your Honor.
for 4
Approximately.
And I know
There were 2 trials, as Your Honor knows.
Right,
so,
right. 2 trials going on simultaneously. But my problem is that we have 4 or 5 volumes of the appendix. Yet we have in one volume, you have testimony by Proctor in let's say in volume 2, and then it shows up again and all over. It seems as if that in many of the in the record, things were taken out and submitted to us. There might be some things missing that the jurors might have heard that constitute evidence that we may not have before us, because I can't imagine that the totality of a 4 weeks trial is entombed in the appendix that we got. Now it's up to the appellants and the parties to get together to submit that. But we have to be very careful in a case of this length and the limited record that we have. Am I correct? We have a limited record before us insofar as the evidence and the testimony of everybody?
Your Honor, that is correct that the joint appendix does not reflect every issue in that 4-week trial, or every piece. We tried to compile them what we thought at the time was the most important thing. But going to damages, Your Honor.
Absolutely. No, I am talking about even the evidence on damages. Suppose there are other things that might have came out concerning damages that we don't have before us, and that might be my problem.
Understood, Your Honor.
Let's go to, is it Attorney Rea, you're going to be arguing?
Yes, Your Honor.
Okay, your 30 minutes starts.
Very good, sir. Thank you. And may it please the court. Good morning, everybody. I'd like to just jump right into these arguments, and I'd like to start by addressing what seems to be the main complaint, and that is that our awards, both compensatory and punitive, were just too high. Let's start off with punitive awards. As you're well aware, the United States Supreme Court in BMW versus Gore articulated a 3-pronged test for measuring punitive damages, and it expressly states, quote, "The most important indicium of the reasonableness of punitive damages award is the degree of reprehensibility of the defendant's conduct." And the Supreme Court emphasized that and broke it down into component parts in State Farm Auto versus Campbell. 5 factors it asks you to look at in evaluating the reprehensibility of the conduct. Was the harm physical or economic? In this case, it is horrendously physical, which is the worst level. It's pain, suffering, cancers leading to ultimate death. Did the conduct show indifference to or reckless disregard of health or safety of others? In spades. This case, the jury listened for more than 4 weeks to detailed testimony, saw internal memoranda from Lorillard, indicating that Lorillard was well aware of the health effects of tobacco, particularly of nicotine, which is highly addicting, yet it manipulated the nicotine contents of cigarettes to ensure addictiveness. It denied science, it denied medicine. It launched advertising campaigns to basically to attract people, and specifically it targeted youngsters. The jury saw, as your honors have, the internal memorandums in which Laura Lard bragged that the base of our business is high school students. And the CEO responds by saying, not, oh, this is terrible, don't do this. He responds by saying, congratulations. This is off the scale as far as indifference and reckless disregard of health or safety of others. The court asks us to look at whether the conduct was an isolated incident or repeated. This is repeated conduct that goes over 5 decades of deception in which Laura Lard and other tobacco companies actually joined together in a conspiracy. The jury finds that they engaged in fraud, in conspiracy, and deceit. These are all intentional torts, which goes to item 5. Was the conduct the result of intentional malice, trickery, or deceit, or was it mere accident? It was no accident that they targeted children, that they manipulated the level of nicotine to ensure addictiveness, and that they misrepresented and denied science and medicine. These are intentional torts. So this is off the total scale. That's what the jury had to consider, and that's what the Supreme Court tells us. This stuff about 1-to-4 ratios or 1-to-1 ratios, I would just remind you when you read State Farm Auto versus Campbell, that the Supreme Court says that there is no bright line rule or mathematical formula, that we look at all these various factors. In Campbell itself, the court approved $1 million compensatory, and of course it said that's not going to support a big punitive claim because the conduct was not so reprehensible. It was an economic failure of an insurance company to pay a claim in a timely manner, and it dealt with nothing like we have here. But
did
Campbell
it also say that it should really go above single digits?
Yes, Your Honor. Again, I'd remind you that the Campbell Supreme Court case stresses that, quote, the precise award in any case must be based upon the facts and circumstances. There are no rigid benchmarks that a punitive damage award may not surpass. So I would suggest, Your Honor, that what we're looking at here is reprehensibility that goes totally off the scale, as with all the other factors. You had, again, six
all the other tobacco cases, you had the same reprehensible conduct. And can you give us any verdicts that have gone punitive damages that have a higher ratio than single digits?
We have a series of them that I could give you, Your Honor, and I would just mention the ones cited by Reynolds are basically many of the Florida cases. In those cases, the juries came up in the same range we were, but the Florida courts remitted the verdicts back down. We, of course, have Antilles school case, which says that remitter just doesn't apply in the Virgin Islands. Instead, you have to ask questions about sufficiency of evidence or constitutional standards. So yes, we are seeing juries across the country coming in at the same range that they are in the Virgin Islands. And we're seeing that, other courts obviously applying the same standards that their laws require. But here, I just point to you for some other cases, Your Honors. We cite In Re Actos, that approved a 25-to-1 ratio. Bullock versus Philip Morris was a 16-to-1 ratio. Williams versus Philip Morris upheld a punitive damage award of almost $80 million. The ratio exceeded 100-to-1. That one actually went up to the Supreme Court on a different issue, but the Supreme Court saw this issue, and the Supreme Court didn't say anything about it, simply remanded it back down, and it was approved at the lower level. Dolkin versus Philip Morris, again, California, cert denied. $50 million punitive award approved. So yes, we're seeing cases like this around the country. To take Florida and say, what ends up as the ultimate result in Florida is where everyone else needs to come out, doesn't make any sense. Here you had 6 Virgin Island jurors who listened for 4 weeks to all of this, who unanimously decided this is the fair result. We're supposed to punish and we're supposed to deter. This is what we need to do. And I would just remind you, Your Honors, that this award that Reynolds say is exorbitant, we put on evidence that was heard by the jury that Reynolds has a net profit every day of about close to $12.5 million. So this
that that was the exact amount of the punitive and Brown, right?
Basically penalized them for 1 day's net profit. That's a slap on the wrist. We're not talking about awards that are off the charts.
That's the punitive that it gave with a $70 million compensatory. So
right. That's correct. Yeah, that punitive in Brown is less than the compensatory as well. So,
Attorney Rhea.
Yes, sir.
Something has come up. It seems to me as if that jurors in the Virgin Islands might have a different consciousness compared to jurors in Florida. Because when I read all of this, particularly the doctors and the expert testimony, this company knew what they were doing.
No question.
They took the young people at age, at pre-teenagers, teenagers, and they even testimony as to Mr. England that they bait them with the cigarettes by leaving them in the apartments on the doorknobs and whatnot. Now, who would want to do that except a company that would have a profit motive? And not only that, but when you think in terms of what the jurors heard the testimony of these expert witnesses, how they know and they could manipulate the amount of nicotine, they could lower it or put it up, they can make it addicted, they can make it non-addicted, they can make cigarettes that's non-inhalable, that you don't have to inhale them. There's so many things that the jurors must have heard that this company could have done to save these people. Maybe the jurors here have a different level of consciousness as to what is wrongdoing and what you call reprehensibility, because they heard it all. I haven't read everything that they heard, but it seems to me as if that they must have been moved by some of the things that they heard coming from these expert witnesses, and the kind of damage and suffering that particularly Miss Brown suffered, how she suffered. And this thing about, well, we didn't put a cigarette to the mouth of the individual. Well, you don't have to. Once you embedded, as one expert witness said, once you embedded that nicotine in the brain, as you smoke, it's go through the veins, by the blood, it's taken to the brain, and it can stay there for a long period of time. Now, one of the witnesses even said, sometimes you might have to, in the old days, you would have had to smoke these things for weeks before you get addicted. But now today, in no time, just a couple of cigarettes and you are addicted. It all depends on what was the nicotine level in these cigarettes, according to the experts. And Lorillard definitely had the ability to make it addicted or non-addicted, and they choose to make it addicted. And once the people get addicted, it's not easy to get off of it, no matter how you get your patch or what.
Attorney Rhea.
Yes, sir.
Would Reynolds ever be able to defend itself in these cases without having to, to be basically preempted with this ABC argument, the con man argument? Are they entitled to defend themselves in a particular case based on the evidence in that case? And when you start off by saying they're going to come up here and they're going to give you this ABC argument, and there's the con man blaming, the victim, doesn't that cross the line really? Aren't you criticizing them for putting on a defense? The minute they come and says, well, this wasn't caused by cigarette smoking, that this cancer was caused by something else, doesn't your arguments really prejudice the jury against them?
Your Honor, with all respect, I don't believe so. First, if the jury was enraged or mad, if it's because of the conduct of Lorillard, I mean, this as Judge Swan pointed out.
Didn't they have a right to come in and say, well, this small cell cancer, that is not the cancer that she has. She had a different type of cancer. without being bombarded by the fact that what happened 50 years ago, this ABC argument is going to, you always have to just get an expert to mention it, and then you can use that throughout your and especially in your rebuttal argument, when you know they don't have a chance to come back, and you leave the jury with that, con artist argument. And the fact that other courts have criticized those particular arguments, then that give you some pause and driving it home time after time?
Your Honor, first I'd point out, if we could just break this down, in the England case, there were no objections at all raised by them during the opening. In the England rebuttal, I referred to what we had seen as a horrific product, and they didn't like that, but that is absolutely based on the record, and it's exactly what the Surgeon General said about tobacco, so there's an evidentiary basis for that. We never argued that they didn't have the right to present a defense. We attacked the defenses, though, and we had the chance to rebut them. And that's what the Sowers case says you can do.
You said in particular they're going to come up in this case and make this ABC argument. So it's not as if you are making a general statement. You are attacking their defense in this case.
Definitely attacking their defense, but not saying they don't have the right to raise it. And again, what they raised with respect to, say, England, Lucian England, is that he must have gotten this from something else. Maybe it was the Tutu Wells aquifer, even though they had no evidence that he ever drank a drop of water from the Tutu Wells. In other words, they do the same with Ms. Brown. They say, well, it must be a different kind of cancer not caused by cigarettes, or maybe, whatever. They continually say it is anything but cigarettes. And that is what they were arguing, and we had the right to respond to it. And that's, as we see, exactly what we did.
Attorney, for all intents and purposes, this anything but cigarette argument, I don't see it to be such an egregious argument, because that's exactly what they did. They pointed to other factors, including the voluntariness of the victim, saying it's kind of suggesting, well, the victim was the one, nobody put a cigarette to their mouth. One. Number two, in the part of England, anything but cigarette, when they start to have this litany about the Tutu Wells, he lived in that area, he might have drank the water, and it goes on and on and on. They even talk in terms of Brown. So to say that they're gonna come up and argue anything but cigarette, that's precisely and exactly what they did. Now, I would admit that using harsh words like referring to it as a conman argument or something like that, that might be one thing. But to say that anything but cigarette was not the thrust of what they were saying that these people have cancer, but you got to be very careful, jurors, because it could have been these other alternative things that might have caused them to contract it. So, and much ado was made that Laurie Ladd, neither Laurie Ladd nor R.J. Reynolds made Marriott, because she only smoked the Newport for about 6 years. And they suggested that, well, but she smoked other cigarettes other than Newport, So it could very well be that it has nothing to do with Newport. It might have to do with Marriott. It might have had to do with some other argument, some other cigarettes that she might have smoked. I don't think that they had gotten to Parliament cigarette. But this argument of anything but cigarette, I don't find that to be too egregious. What I would say that they are suggesting that it's a con man or something, that is one thing. But do they have a right to defend it and say that there were other people or other causes for this cancer? Of course they had an absolute right to do that. Of course they had an absolute right to do it. And they proceeded to do it, and it came out in the evidence. So for somebody to come in and talk about it before the jury, it's already was in the record. Not a harsh language of conman business, but the fact that there was an alternative cause for this cancer other than the cigarette that we produced, which was the Newport, which was the only cigarette that she was smoking produced by us. But she smoked other cigarettes that were not produced by us, such as the merit.
If I could just briefly address the con man argument again. We had charged fraud, and the jury actually found fraud. And I'll just remind you that that's what a con man does. He commits fraud. He puts something over on innocent victims, which is exactly what they were doing when they denied science, when they put out false advertising, when they entered into a conspiracy with the other tobacco companies. That they're doing exactly that. And we raised that analogy in the rebuttal when they kept saying it was the victim's fault. It was the fault of Brown and the fault of England because they put the cigarette to their lips. And what we're saying is, and I think we said it pretty clearly, is that, you know, you addicted these people. You persuaded them that it was, and played on their hope that they could smoke because being addicted, they wanted to keep doing it. You played on that by saying, well, the science doesn't really say it definitely is going to cause disease. You got some, you know, don't worry about that. That's what con men do. And I respect, obviously, if you think that that was a too strong way to say it.
In other words, if I understand you correctly, you are saying that these internal documents by Larry Ladd, the big meeting in New York among the high echelon people, they're going before the Congress and suggesting that, well, you know, that there's no science yet, there's no linkage yet, but knowing, according to the record, full well that there was in fact a linkage between cancer and cigarette smoking for years, and they had all this information. If you're saying that they had all this information, they know that they could have manipulated the nicotine content of the cigarettes to make it non-addicted or addicted and all of these things, then that is one thing. That's where the fraud would have come in terms of doing all of these things, knowing full well that it was going to injure people. That's what I understand is the argument that you're making.
Yes, sir. And I would just, to wrap this one up, if I could, just remind you again that these statements made during the course of closing arguments take a couple of hundred pages of transcript. We're looking at a trial that, after everything was said and done, was more like 5 weeks, with the jury listening to the evidence in some detail. Again, the trial judge was sitting there listening to all of this. He didn't find that any of this required a new trial or was unduly.
Well, he didn't rule on the motion.
No, but he didn't grant it. I mean, that's the big thing in our sense.
He didn't rule on it.
No, he did not, which meant he didn't jump in and grant it, and he was well aware that if he didn't rule, it would be deemed denied.
He sustained the objection to your argument, and then you continued right on. And when another objection was made, he overruled it. So, you know, it seems to me that, well, let me just ask you now on this $70 million verdict.
Yes.
What is your response to the appellants that is basically, you know, unreal?
Okay. Yeah, obviously it was a $50 million for Patrice Brown and $20 million for her son, Christian. I just remind your honors, with respect to Patrice Brown, she was diagnosed with cancer in 2008. She lived until 2013, and the jury heard in tremendous detail from her, because she had been videotaped before she died. So they were able to look her in the eye, judge her credibility, and hear what she had to say. She talked about a deterioration of her body. I mean, it is painful to hear, and it was powerful testimony. As she described what it's like to have terminal cancer, to know your death is approaching, to feel your body organs go, the cancer metastasizes to her brain. It was a horror show. And the jury listened to all of that, saw her face on, heard from her doctors about exactly what she had suffered from, and made a conclusion unanimously. All 6 Virgin Islanders sitting there on that jury unanimously concluded, this is what that's worth. This is the fair value for that. And the same with her son. I know the arguments made, well, he was an adult, he didn't suffer that much. Again, the evidence was in much more detail. He testified in person, by the way, and other people corroborate him. He told that jury and looked them in the eye, and they believed him, gave him credit that she was his only parent. He didn't have a father. he and she were
You know,
extraordinarily close.
in a Virgin Island case that gives that type of a verdict for a wrongful death or even a survival action?
I, quite honestly, haven't looked through the whole range of Virgin Islands cases that cover that. I know I've tried many wrongful death cases, and the ones that I tried have not reached that level, although some of them were what you, I guess, would call up there. Which raises another interesting question, Your Honor. I know that counsel for Reynolds has been comparing our verdict to those in Florida. Just think what would have happened if, let's say, the first of these cases had been tried in the Virgin Islands and they followed the same pattern as the one we're sitting with here. Then the standard for what would be fair for reprehensibility in cigarette cases would be, you know, where we are now, 30, 40, 50 million. But to say that we have to compare this with Florida, just because Florida was the first one to go and has tried a lot of them.
You consider the reprehensibility on the compensatory?
I'm sorry, sir. Do I consider?
Yeah, you keep referring to the reprehensible conduct. Do you look at that in terms of the compensatory or
No.
just for punitive?
You're right.
So that's why I'm asking you on the compensatory.
Right.
Can you tell me any other relationship either in the Virgin Islands or even elsewhere with respect to tobacco cases where you get a verdict of 50 million for a wrongful death and 20 million in a survival action?
I know in Florida, after remitter's taken place, they don't end up there. I can't tell you exactly what
In other words,
like before remitter.
no court has sustained a verdict of that size.
Not that I'm aware of, Your Honor. No. That doesn't mean, though, that a verdict of that size is not justified in certain circumstances. And we
turns out not to be justified in this case. What does this court do in light of Antilles?
I believe in light of Antilles, this court needs to look at the verdict and say, is this verdict not supported by the evidence? Is there insufficient evidence? Or is it so out of whack, so high that it violates the constitutional standard? It's unconstitutional, violates due process. And I think that's what this court can do. I also believe, in response to an earlier question you asked, that this is a matter of law. And we're not asking for you to remand if you decide the verdict is too high. We believe that you can, as a matter of, since you are the organization that decides legal issues, you can determine what is the highest permissible verdict based upon this evidence under the constitutional or sufficiency standards. So we would defer to you.
Unlike the punitive damages that the appellants seem to agree that we could reduce it to a constitutionally sufficient level. You're saying we could do the same with respect to the compensatory without giving you the option of a new trial?
Right. I believe you. I believe you can. Yes. And I believe it for this reason. Obviously, Antilles says there's no more remitter. The judges shouldn't substitute their own idea of a correct verdict for what a jury's come up with. But what can happen with verdicts is if they are unconstitutionally high, or if there is no evidence to support the verdict, that it can then be changed. And so what we'll be asking you to do, if you decide that this verdict is unconstitutionally high, is to tell us what is the highest permissible under this entire fact pattern. And we believe that you would be the best party to do this. I think it's the most efficient way to do it. You've reviewed the record, and that is your institutional role. And so we don't.
But I see that more on the punitive. But what would be the constitutional basis for us to determine that a $70 million compensatory damage should be some lesser amount? who I know have now retired, but could be called back, I guess. Should that judge have the first opportunity? I know he didn't take advantage of the 120 days after the judgment to do it, but
I would respectfully suggest he is retired. I don't know whether he would or could come back to do this. And in many ways, he having actually seen the witnesses and seen the decedents, he would be a judge who would be best positioned. But then again, this is since he has to pass on the constitutionally permissible level, that again, my sense is that would be a matter of law, and that's something that you as a court that determines law should do.
Attorney Ray, do you know any case in the Virgin Islands where a plaintiff's lawyer has asked for a certain amount and the jury has come back and more than doubled the amount? I'm referring, of course, to the Brown case, where the plaintiffs seem to have underestimated the case according to the jury, or the value of the case. They asked, I believe, for 20 million for the estate and 10 million for Mr. Brown, and they got 70 million, more than the 30 million. Do you know of any case like that in the Virgin Islands?
Not exactly like that. As Your Honor is aware, I've been trying cases in the Virgin Islands for about 35 years, and I have had juries come in higher than I've asked for, although not by that much, but those cases weren't involving numbers like that. And again, sometimes we lawyers underestimate things. That jury sat there and listened to everything, and there's no claim that they were in any way biased or that in any way, that any juror should be stricken or they had outside influence. They were good jurors. They were ones we'd selected. And they concluded unanimously, this is the number that's fair based on everything that we've heard. And that's why we think that verdict should stand.
Your time is going to run out, but I'd just like to ask you, you believe that the court was correct in ordering prejudgment interest on these verdicts?
Yes, Your Honor, we do. I'd be glad to address that one. The couple of reasons. Obviously, we have a statute that covers interest. That's 951A1 that states that the rate of interest shall be 9% per annum on all monies which have become due. Some courts have read into that, well, the amount has to be directly ascertainable. And again, this is sort of extra words that have been read into the statute, we think runs afoul of the doctrine that you all articulated in Rennie. If you were to read just do a straight statutory interpretation, if you look at 11951A3, the court in A3, the statute in A3 talks about ascertainable and says that if you're going to be collecting basically on something that's due under a mortgage, it has to be reach the level that it's ascertainable. So the court, so the legislature knew how to say ascertainable.
I read with much interest your brief, but look at the language here. It says all money which have become due.
Yes.
When does the money become due? Isn't it come due when a judgment is entered validating the claim? Or when is entered validating the claim, the date of the judgment, whether announced from the bench or what. But if I understand it correctly, you may want to go back further back than the date of the judgment. Am I correct?
Yes, sir.
And you want to go back? How far back do you want to go?
Well, Judge Dunstan agreed that we should go back at least to the point where a claim was filed, where the complaint was filed, because that obviously put the defense on notice.
But the only thing that a complaint says is that I am asserting a claim against an individual or against a party. But for all intents and purposes, when it says, and I look at it upside down, right side up, and it says, The rate of interest shall be 9% per annum on all money which have become due, which have become due. Become due, which have become due means that, as far as I'm concerned, it seems to me as if that it doesn't become due with the filing of the complaint, though. It seems to me that it comes due when the jurors bring in that verdict and says this is the amount of the judgment that we have, after reviewing the evidence, listening to the instructions of the judge and oral arguments and closing arguments, is our considered opinion that this is the amount that is owed. But if you want to, because a complaint doesn't say that you are owed anything. A complaint is nothing more than allegations saying that, saying to the court, I'm entitled to recover X, Y, Z. Even if they put in a figure, that figure does not become due until such time as the judgment is entered. Am I correct?
Your Honor, if I could just, that issue's been looked at by the Alaska court.
Yeah, I know.
And that's what our statute was modeled after. State versus Phillips, the Alaska court's looking at the same language, said, at the moment the cause of action accrued, the injured party was entitled to be left whole, became immediately entitled. All damages then, whether liquidated or unliquidated, pecuniary or non-pecuniary, should carry interest from the time the cause of action accrues. And
it does that. You cited 11 GIC 951A1.
Yes.
Is that the subsection you're going under, or any of the other subsections? Because I don't see how you're going to go under any of the other subsections.
No, that's the one.
Subsection A1.
That's the one we're going under, and that's the language that State versus Phillips was looking at, and they looked at it from a policy situation. They said, look, this doesn't say whether the amount has to be ascertainable right at that moment, but every day that an injured person doesn't receive compensation is a loss to that injured person and a gain to the wrongdoer. And we don't want that to happen.
I heard that argument. But you do not determine fault and negligence until such time as the finder of fact determines that.
Didn't some of the injury occurred a week, 2 weeks, 6 months before the case was tried?
Well,
if you give interest back to when it's filed, does that make sense? That's money due at that time?
Well, that means that the injured party is not being compensated consistently, and the wrongdoer is keeping whatever the fair compensation should be and has use of that money and is basically profiting from it. And that's the balance that's been struck. I know we took a look also at a lot of BI cases.
But let's look at it. Let's look at the statutes for the wrongful death and survival. Doesn't that state what damages are recoverable and what should be with interest?
Right, but that doesn't preclude prejudgment interest. It's silent on that issue.
I'm talking about the statutes. The wrongful death statute doesn't reference the prejudgment interest statute in Title 9, does it?
No, it doesn't. It doesn't mention the prejudgment statute of Title 11, 951. No.
Okay, well, we're really going over your time, but I just want to ask you on the comparative fault.
Yes.
Why did you ask the jury to assess comparative fault if you were going to then argue that it wasn't applicable?
Well, once juries, when juries deliberate, you never know what they're going to end up doing. And if they only do a negligence claim, then obviously comparative fault is going to be critical. If it's if they come in with the intentional tort claim, then as we point out in the common law, statutory law, and law of the Virgin Islands, there is no offset. But you don't know what a jury's going to do. That was part of the jury instructions that were put forward.
But our comparative fault statute doesn't give an exception for intentional torts, does it?
No, but it says that it applies to any action based on negligence. That's its language.
Right.
And intentional tort is not based on negligence. And and I know I know Reynolds tries to argue that, well, the gist of this whole case is negligence. No, the gist of this whole case is intentional wrongdoing. There's no question about that. And we've already talked about that. So no, this does not fall under the comparative negligence statute. I'd point your attention also to footnote number 12 in our brief, where we show that across the country, comparative negligence is not applied in intentional tort cases. The only time it is when the legislature has passed a statute that makes it applicable to intentional tort, such as say in Michigan. There's like 2 or 3 jurisdictions that are like that. But otherwise, they do what we've always done. There's no offset. And again, there's strong policy reasons behind that. You don't want to give a windfall or an advantage to intentional tortfeasor, somebody who sets out intentionally to harm others.
Thank you.
Thank you, and thank you for giving me some extra time there to answer
Mr.
questions.
Carvin, you have 6 minutes for your rebuttal, and I assume you'll try to address some of these questions that you didn't get to.
Yes, thank you, Your Honor. I'd like to begin with prejudgment interest. In Brown alone, they were awarded $47.8 million in prejudgment interest, which is a huge penalty. The district court gave no reason for this, but it's contrary to at least 40 years of Virgin Island law that prejudgment interest is not available for personal injury torts. And the restatement says that, and most important, it's contrary to the plain language of the statute authorizing prejudgment interest. As was pointed out in the prior colloquy, it's only prejudgment interest on monies that have become due. Well, if the harm is pain and suffering, the money never becomes due until the final judgment. This is not a dispute about money, as my opponent was emphasizing. We didn't visit economic harm on the plaintiffs. We visited physical harm on them. That's why they call it non-economic damages. Therefore, the only time that 951A1 applies is when there's a financial dispute, you withhold the deposit or you don't perform. Then what do you have? You have an ascertainable time when the plaintiff should have had the money, but didn't because you withheld it. Well, that has no application when you're not talking about a dispute about money. You're talking about a infliction of harm, physical and psychological, because at that point, there's no money due to the plaintiff. There's no money that the plaintiff could have used during the time. So awarding prejudgment interest in these circumstances is not making the plaintiff whole, it's giving them a windfall. I don't know what plaintiff's theory is. Is it that when Ms. Brown checked into the hospital, we should have written her a check for $50 million or some amount equivalent to that? In other words, nobody knows the amount in a non-financial dispute of what the economic damages are going to be. So it's quite impossible to give them the money to make them whole until the jury has come in with its verdict. So that is why under this statute, it makes no sense, because there are no monies due. There's no argument that we owed them money. What we owed them was a duty not to harm them. And that is why under the common law, and they argue they should be judged by the common law, which is wrong because they waived it and because the statute governs here, not the common law. But even under the common law, under the restatement, under 19 different jurisdictions that we cited in our brief, you don't get prejudgment interest on personal injury torts. Why? Because pain and suffering is not a monetary dispute. The theory of prejudgment interest is on ascertainable date X, when I owed you your deposit or I owed you the money under the contract, you would have had that money in your pocket and been able to invest it. Well, that just doesn't apply. There is no ascertainable date here when we owed the plaintiffs any money, which is why they simply plucked the date of filing suit out of the air. Why isn't it when she checked into the hospital? Why isn't it when she suffered pain after the complaint was filed? And when they could have used that money, which is why the statute, the common law, and as Your Honor pointed out, the wrongful death statute don't allow prejudgment interest for pain and suffering. And contrary to my opponent's suggestion, the wrongful death statute speaks directly to prejudgment interest. It says you get it for lost earnings and lost support, but you don't get it for pain and suffering. So there's really no argument here that this is authorized by either the common law or statute, and the penalty is enormous, almost $48 million. So we ask that be stricken. In terms of the other issues,
How about the comparative fault?
I apologize, Your Honor. That's my attorney Francis's issue. If you had a particular question,
yeah, but she didn't get to it. Okay, I understand what you're saying.
I'm in a bit of a dilemma here. If you had a particular question, I'd struggle to answer it, not as well as my colleague could, but I think our papers speak to that.
You agree that all of the courts essentially says that where it's commingled with intentional thoughts that they should not be applied. The comparative fault should not apply.
Well, they chose the language in action, including negligence. They didn't just say for negligence claims. So you need to look at totality of the action. And as my colleague pointed out, the totality of this action was about negligence. We shouldn't have had unsafe cigarettes. So I think that's our essential argument. If I could make two quick points on punitive damages, if at all possible. The argument that we were really reprehensible in tobacco cases and therefore the ratio should be discarded is again a frontal assault on the Supreme Court's analysis about that the ratios apply in all cases. The Florida courts and other courts in tobacco cases have looked at these same facts and not allowed it. In addition to the Florida cases, Borner simply said it was a 1-to-1 ratio. As to the notion that the Virgin Island juries might be different than other juries on the mainland in Florida, that's the problem. It's not the justification. The court has emphasized, the Supreme Court is, what we need is some uniformity. What we need is some notice. We can't allow the individual passions of juries who are understandably incited when they see bad facts in front of them to determine what kind of punishment would happen. We need a uniform system. There's one Constitution in the United States that applies in the Virgin Islands and everywhere else. We can't have one Constitution for some juries in some jurisdictions and another's for others. So what the court's job is to look at when juries are inflamed by passion and exceed the ratios to bring it back to a uniform standard that puts defendants on notice of what kind of penalties they are being subject to and not be blindsided with 30-to-1 punitive damages over compensatory. The final point about the improper argument, I do want to emphasize that it wasn't just the ABC that we thought was impugning our ability to make a defense, but they repeatedly said that we failed to accept responsibility. Well, that is a frontal assault on even our authority to mount a defense. So for all of those reasons, we think that the prejudgment interest needs to be eliminated. The punitive damages need to be at a minimum reduced to 4-to-1. And we would think that the entire case was poisoned by these improper arguments, entitled to a new trial for that reason. I see that my time is essentially up, and unless the court has further questions, I have nothing further.
On the compensatory damages in Brown, do you agree with your opposing counsel that that this court can set a constitutionally acceptable amount and impose that without granting the right to a new trial?
I'm going to ask the court's indulgence unless you disagree. Would it be possible to have Attorney Francis answer that question? I know we're over time, and would that be amenable to the court? That's in her bailiwick.
Yes, Attorney Francis, you got 1 minute.
Thank you. Yes, thank you, Your Honor. I think Antilles is quite clear that on excessive damages, the court does not make a determination. It's sent back for a new jury. So while Attorney Carvin has argued that as to the constitutional issue on punitive damages, this court can reduce to a constitutional amount, on excessive damages, this court has been very clear that it does not make that determination. It sends it back for a new jury. So we don't we don't agree with the notion that this court would make the determination of a proper amount of compensatory damages under the reasoning of Antilles. And may I go on, Your Honor?
I think you've answered it. I think you actually said it before. Okay. Thank you all.
Thank you very much.
Thank you,
Matter
sir.
is submitted.
We appreciate the court's time. Thank you.